Our next presenter is Matt DeRuyter. Matt is an associate at Kinney & Lang, and he'll be talking about what is meant by exceptional cases now after some new developments in case law over the past year. So, Matt?
Thank you, Ryan. Thank you for being here. I was going to give Alan a hard time for not giving me much time before the Spain-Netherlands match started, but we've already passed that point. If anybody has updates, feel free to shout them out as we go along. Let's see. Okay, today I'm going to talk about exceptional cases after the Supreme Court decisions in Highmark and Octane Fitness. So what exactly is an exceptional case? Well, in certain instances, a non-prevailing party will behave so, misbehave during the course of litigation that the court will decide that they need to pay the attorney's fees for the prevailing party. It's, in essence, kind of a fee-shifting arrangement. I'm going to talk a little bit about the history of fee-shifting, talk about a 2005 Federal Circuit case, Brooks Furniture, that kind of laid out the framework for determining an exceptional case, actually more refining it than determining it. And then talk a little bit about Octane Fitness and Highmark. Two recent Supreme Court decisions were issued for these cases, and then go into a short hypothetical discussion as well. So some fee-shifting history. We are very used to what many practitioners refer to as the American rule in the United States court system. And that is, win or lose, each litigant pays his or her own attorney's fees. It's something that we've gotten used to over the course of several centuries. It's something we understand, it's something we accept. In 1946, Congress did act to adjust the patent laws to add a discretionary fee-shifting provision. And there, the statute read, a court may in its discretion award reasonable attorney's fees to the prevailing party upon entry of judgment in any patent case. Now, if you look back at the legislative history as Congress was acting here, it was clear that they didn't intend for this to be a regular occurrence. It was more a safeguard in there to discourage someone from infringing a patent, thinking that all they would have to do if they lost the patent suit was to pay a reasonable royalty. And it was also there to prevent gross injustice to accused infringers. Just 6 short years later, Congress amended the Patent Act again, and there we see the fee-shifting statute of today. It's short and very straightforward. The court in exceptional cases may award reasonable attorney's fees to the prevailing party. Just a couple statistics I found interesting as I was putting this presentation together. Going back to about 2005, when the Brooks Furniture case came out at the Federal Circuit, we've got 206 cases in which the patentee tried to get attorney's fees from the accused infringer, and about 249 cases in which the accused infringer tried to get fees from the patentee. What's interesting to me here is I expected far greater numbers of accused infringers trying to get attorney's fees, especially during this time frame where 2005 to 2012, some would say this is kind of the rise of the patent troll. I would have expected a larger number of cases here, really only about 20% greater than what we see from patentees. So let's talk a little bit about Brooks Furniture. Dutalier is a Canadian family-owned company, and they are the owner of a design patent, the subject matter of which is rocking chair trim. So the design of the rocking chair, and you can kind of see on the slide there a little bit about what it's talking about. They obtained this patent, the 983 patent, in December of 1999, and then in January of 2000, a mere month later, they sent a cease and desist letter to Brooks Furniture. Brooks Furniture is a US family-owned company, and they alleged an infringement of this design patent. And in response to that cease and desist letter, Brooks Furniture sought a declaratory judgment. They also alleged that the action was exceptional under both the patent statute, the Lanham Act, and state consumer protection law. Before I get into the district court analysis of the case, a little bit of additional background primarily on Dutalier. They did try to sue Brooks Furniture for patent infringement, among other things, in Delaware. However, once they were unable to transfer the case from Tennessee to Delaware, they brought those same claims in the Tennessee action. Dutalier did do some investigation prior to sending out their cease and desist letter. That included an analysis by marketing staff and designers, patent opinions or infringement opinions by patent attorneys, as well as evaluation by experts in the field. Other interesting things to note include the terms of the cease and desist letter. The terms of that letter required the withdrawal of all accused products from the marketplace, as well as to identify all the customers who purchased them, and that's all had to be done within 2 weeks. In addition to that, Dutalier had no showing of a willingness to license the patent to Brooks Furniture. And both courts also noted some prior conduct by Dutalier. They had filed lawsuits against competitors related to other patents, and even acquired one of the competitors after suing it. So what did the district court do? The district court granted summary judgment of non-infringement, and it denied summary judgment of invalidity as being moot. It also granted Brooks' request for attorney's fees. It said the attorney's fees are warranted under any one of the three bases that Brooks Furniture alleged. The court explained that design patents are construed very narrowly, and that Dutalier's activity was not enough to establish a good faith belief that Brooks Furniture was actually infringing. And so Dutalier appealed, and the case went to the Federal Circuit. And here, the Federal Circuit really laid out the framework for exceptional cases, and I'm going to break it down into two categories. The first is going to be one where there's inappropriate conduct related to the litigation. This is going to be your litigation misconduct type activities, willful infringement, fraud before the patent office, misconduct during litigation, vexatious litigation, Rule 11 violations, things of that nature. So fairly serious offenses. What's going to be more interesting is the second category, where there is no showing of litigation misconduct. However, fee shifting can occur in some circumstances. And this is kind of new, and this is going to be something that I'll be talking about in more detail throughout the presentation. The court said that sanctions may be imposed against the patentee, but only if the litigation is brought in subjective bad faith and the litigation is objectively baseless. So it talks a little bit more about the subjective and objective parts of that framework. Subjective bad faith, it needs to be shown at the time suit is brought, and the suit being objectively baseless, it doesn't depend on the patentee's state of mind when the action commenced, but rather requires an objective assessment of the merits on the whole. The Federal Circuit did say that improper conduct and characterization of the case is exceptional and needs to be established by clear and convincing evidence, and that a decision to award attorney's fees is within the district court's discretion. So after laying out the framework, it went through the factors, the facts in the Brooks Furniture case, and it disagreed with the district court's view that opinions of counsel were inadequate and their conclusions unreasonable. They noted that infringement is a difficult thing to determine, and at one point quoted, "A patentee's ultimate incorrect view of how a court will find does not of itself establish bad faith." So essentially, the court found no clear and convincing evidence of bad faith by Dutalier in bringing suit against Brooks. The exceptional case finding was reversed, and the award of attorney's fees vacated. So the Brooks test, established in 2005, gets refined over time until about 2012 with a number of other cases I'll be talking about very briefly. But now I'll turn to the Highmark and the Octane Fitness cases. These are the ones involved with the Supreme Court decisions. Allcare was a health management company that owned a U.S. utility patent. The patent was directed towards healthcare management systems. And Highmark is a Pennsylvania insurance company. Highmark sought a declaratory judgment in the Western District of Pennsylvania. The case ultimately ends up getting transferred to a district in Texas, however. There, Allcare counterclaimed for infringement. 3 claims were at issue here, and a special master was appointed to resolve the claim construction. After the claim construction by the special master, Highmark moved for summary judgment of non-infringement, and Allcare opposed the motion with regards to claims 52 and 53, but withdrew its infringement allegations with regard to claim 102. The district court ultimately ended up entering a judgment of non-infringement, and Allcare appealed that judgment. The Court of Appeals for the Federal Circuit ultimately affirmed that non-infringement issue without a written opinion, and at that point, Highmark moved for an exceptional case finding under the patent statutes. The district court, ruling on that motion, ultimately found that the case was exceptional. It found that Allcare's attorneys violated Rule 11, Allcare engaged in litigation misconduct, and it awarded fees to Highmark in excess of $5 million. Some of the litigation misconduct that the court noted was res judicata, collateral estoppel, shifting claim construction positions during proceedings, as well as making misrepresentations with respect to a motion of venue transfer. Ultimately, Allcare's attorneys withdrew from the case. They were able to get the Rule 11 sanctions dropped, and Allcare moved to have the exceptional case finding reviewed. The district court denied that motion, and so Allcare appealed. So the case went back up, or not back up, but went up to the Federal Circuit, and there, in the opinion, the Federal Circuit kind of laid out the Brooks Furniture framework, as well as how things have changed since 2005. The court noted that the objective-subjective standard is applied on a claim-by-claim basis, and that it not only applies to patentees but accused infringers as well, citing the Eilor Google case from 2011. It also took a look at the different prongs of the second category, so subjective bad faith and objectively baseless. The court did note that there's a presumption when an assertion of infringement is made for a duly granted patent that it's being made in good faith. And so the prevailing party is going to have to kind of overcome that. It also noted that bad faith is established with clear and convincing evidence, and the Federal Circuit also indicated that it would review factual findings as to subjective bad faith for clear error. Turning to the objective prong, the court described it as a question of law based on mixed questions of law and fact, and that the determination must be made by the court, and that the Federal Circuit would review these decisions de novo. So, Federal Circuit took a look at the facts of the Allcare case and ultimately affirmed with respect to 102 and reversed with respect to claims 52 and 53. Here, with respect to claim 102, under the de novo standard, Allcare's infringement claims were objectively unreasonable. At the same time, they found that the district court did not clearly err in concluding that those allegations were brought in subjective bad faith. With respect to claim 52, they agreed with the district court as to non-infringement. However, they found that Allcare's claim construction was not on its own objectively baseless. Simply being wrong about claim construction should not subject a party to sanctions where the construction is not objectively baseless. Regarding litigation misconduct, which was also alleged, the Federal Circuit found that none of the actions were sufficient to make the case exceptional. Allcare did engage in some claim construction shifting during the proceedings, but what the Federal Circuit found was that ultimately the idea, it didn't differ in substance, it was just a matter of some modification to the terminology. Judge Mayer dissented in part from his brethren at the Federal Circuit. He felt that the Federal Circuit erred with respect to the deference owed the district court. Rather than the de novo standard, he thought a reasonableness finding should only be set aside for clear error. And then kind of got up on his soapbox about the Federal Circuit's infatuation with de novo review, indicating that it started with claim construction, and now this idea of de novo review had entered into willful infringement as well as exceptional case determinations. Also called it appellate overreaching, and one of my favorite quotes from the case, litigation before the district court has become a mere dress rehearsal for the command performance here. Ultimately, Justice Mayer found no basis for overturning any of the court's determinations and would affirm the district court's case in its entirety, and kind of as an aside, indicated that he felt Allcare's claims should be invalid as non-patentable subject matter. Now we'll turn to the Octane Fitness case, which occurred in the District Court of Minnesota before Judge Montgomery. Icon Health and Fitness is a Utah company. Some of you may be familiar with the brand Nordic Track. Icon Health and Fitness is the owner of that brand. They also owned a U.S. utility patent related to elliptical machines. Octane Fitness is a Minnesota company specializing exclusively in elliptical machines, and Icon brought suit against Octane Fitness for patent infringement. Judge Montgomery entered a summary judgment of non-infringement, and as a result, Octane Fitness moved to make the case exceptional under the patent statute, and the district court denied that motion. The district court's analysis of the Brooks Furniture framework at this point has really kind of been narrowed and focused more based on some earlier cases, one of these being the Eilor case. According to the district court, in order for there to be a finding of objectively baseless litigation, a party's assertions have to be so unreasonable that no reasonable litigant could believe they would succeed. That to me seems, very narrow, as well as the subjective bad faith prong as well. The plaintiff's case must have no objective foundation, and the plaintiff must actually know this. What we've seen since Brooks Furniture is a very driven focus to kind of narrow what someone needs to show in order to get an exceptional case. And I think ultimately this is kind of what piqued the interest of the Supreme Court to take up these cases. As a result of the decision, both parties appeal. Icon appeals the summary judgment of non-infringement, and Octane Fitness appeals the denial of motion to make the case exceptional. Octane Fitness essentially argued that the district court was overly restrictive in the standard in its finding, and that Icon's claim construction positions were unreasonable. So the case goes to the Federal Circuit. The Federal Circuit finds no literal infringement, no infringement under the doctrine of equivalence, and it also finds that the district court did not err in denying Octane Fitness's motion to make the case exceptional. The Federal Circuit kind of felt that Octane was trying to rebalance the power between large companies and small companies in patent litigation by lowering the standard to a level of objectively unreasonable, and the Federal Circuit just wasn't buying that. They also felt there's no reason to visit the kind of settled standard that the Federal Circuit had established for exceptionality. So before we get to the Supreme Court opinions, just to kind of recap here, in both cases, Highmark and Octane Fitness, we have unsuccessful cases brought by the patentee. In the Highmark case, we do have an exceptional case in one respect, but not in the other. And on Octane Fitness, the case is not exceptional. So the cases go to the U.S. Supreme Court. The Supreme Court issues the decisions for both these cases on the same day. Both are unanimous decisions. There's an asterisk here for the Octane Fitness decision, only because Justice Scalia did not join with respect to some footnotes in the opinion concerning statutory construction. Ultimately, the Supreme Court found that the Brooks Furniture Framework is unduly rigid and impermissibly encumbers the statutory grant of discretion to district courts. Basically, it's the Supreme Court reminding the Federal Circuit yet again, you're not getting this right, listen to us. And so what exactly is the holding? Well, the framework has departed from the Brooks Furniture Framework, and in Octane Fitness, the Supreme Court lays out what the framework should be. An exceptional case is simply one that stands out from others with respect to the substantive strength of a party's litigating position or the unreasonable manner in which the case was litigated. So instead of having this Category 1, Category 2 type framework, you need to have something that just stands apart from the others. It's got to be something abnormal, out of the ordinary. Court also said district courts can determine whether a case is exceptional on a case-by-case basis at their discretion, considering the totality of the circumstances. Okay, so the Brooks Furniture Framework is overturned. The Supreme Court does go into more detail about why that is. Basically, it said the framework was too restrictive by defining those two narrow categories, as well as saying that this Brooks Furniture Framework, it basically renders the statute superfluous. There's no, the statute doesn't say anything anymore. It's all based on the case law. They also went on to say that the idea that clear and convincing evidence was needed was not justified by the statute. There is no statutory burden or no evidentiary burden in the statute, and so the Supreme Court has decided to settle on a preponderance standard as being something that it felt allows both parties to kind of share the risk of error in roughly equal fashion. So that's the holding in the Octane Fitness case. Highmark is a very short opinion by the Supreme Court. It basically restates the Octane Fitness holding, as well as talking a little bit about the appellate level of review. Appellate court should review all aspects of a district court's exceptional case determination for abuse of discretion. So this goes beyond even what Judge Mayer had in his dissent in Highmark, where he felt clear error was appropriate. Here it's an abuse of discretion standard, far different from the de novo standard that the Federal Circuit had advocated. All right, so in both cases, the Federal Circuit is reversed and the cases are remanded for further proceedings. So basically the test now has moved from a rigid Brooks Furniture Framework to one where the exceptional case just needs to stand out from those of the norm. So why do these cases matter? Well, based on these decisions by the Supreme Court now, the determination of an exceptional case is a little less predictable. I think when you had that more rigid framework, you understood, based on 400 some cases that were determined between 2005 and 2012, you could kind of match your facts to the framework, how they would fit in, and have a decent understanding of whether your case might be exceptional or not. Now, if it's something that just needs to stand apart from other cases, it's a little bit more abstract, a little more nebulous. Additionally, it may be easier now for cases to be considered exceptional. And we see, I guess since the Octane Fitness and Allcare decisions came out, we have seen a number of parties kind of try to get fee shifting into their cases, and some have succeeded while others haven't. In a Globus medical case, courts denied a fee shifting after these decisions came out, whereas in a Newegg case, the court did allow them to kind of revive their bid to seek fees. So time will tell whether this will be easier. I think if you ask most practitioners, they will say that they believe now it'll be easier to establish an exceptional case. What we'll also see is more discretion given to the district court So that means we're going to see less reversals on appeal. And if the district court makes a finding or chooses not to make a finding of an exceptional case with that abuse of discretion standard, I don't see too many cases being overturned, although that certainly would be possible. I also thought it might be interesting to kind of go through some hypothetical situations, but I will caution this with a big disclaimer that any sort of factor involved in determining whether a case is exceptional or not is going to depend on the totality of the circumstances now at the discretion of the district court. So if we take a look at any one of these different hypotheticals, that by itself may not be enough to establish an exceptional case, but it will certainly be something that is considered by the court. For instance, inappropriate conduct during litigation. Before, under the Brooks Furniture Framework, that was pretty much accepted as something for which an exceptional case would be found. Here, I would say it's probably likely, but think about it. What happens if both parties are misbehaving during litigation? Then maybe it's not so clear anymore, so that whole "it depends" does make a difference. What if the patentee is a non-practicing entity, or one party is significantly larger than the other? By themselves, I don't think this is really going to raise to the level to have an exceptional case on their own, but certainly these things are going to be looked at by the courts. If the patentee doesn't do enough pre-suit due diligence, certainly depending on the magnitude, I can see that rising to the level where an exceptional case can be found, but it all, as I said earlier, it all depends. Same with some of the claim construction positions that a party takes. If it's just flat out ridiculous, then that may lean more towards an exceptional case than if it's somebody just trying to, wiggle enough to get the claims to fall around a particular product. What about if a patentee refuses to license? I don't think that this by itself is going to be enough to see an exceptional case determination made. As well as, if an attorney's fees will effectively force a party to close its doors. I don't know that this is going to be relevant enough to the patent litigation or the patent litigation positions of the parties in order to skew the determination one way or the other. Another one would be if a party is unreasonable in its unwillingness to settle. I don't know if that's going to come down to the decision of the courts, totality of the circumstances, so it's all going to depend. So in closing, I'll just note that the Brooks Furniture Framework, the rigid framework that the courts had used to determine whether a case was exceptional or not, is now gone. Now we've got something that's, I guess, a little more vague, maybe a little easier to meet, and that's that the case just needs to stand out from others. It's the totality of the circumstances test within the discretion of the district court, and the weight the district court gives to that determination is going to be quite heavy. Thank you very much for your attention, and enjoy the rest of your day.
Thanks, Matt.